privilege to be in this very cute city. I am coming here for the first time, so quite impressed to see so many lovely people. It's a great atmosphere, regardless of what the ruling groups are doing to us. We should be faithful to our ideas and committed to fight the good fight for fundamental rights and freedoms that you have undoubtedly inherited from your own forefathers. So it is indeed a total honor to be present. I must thank the organizer of this event for the opportunity to be here. As I always tell, I'm just an academic, and I was not expecting that at this stage, even of my life, I would have to be doing this, because I don't like politics at all. But I'm being forced to speak truth to power, if you can say. So what I'm going to do is to express some of my feelings, and I believe the issue is so important that I shouldn't just speak from my heart, which is going to be the case, but also to be 100% sure that I'm not going to miss anything that are potentially important. So I decided 3 days ago, basically, to write a paper just for you, in honor of those who are present. So perhaps I'm not going to be all excitable and as I do to my students. That's why I have been sometimes elected by them as the lecturer of the year. But today I need to be really careful about having the right words for you, because you need to know exactly what's happening and how Constitution and even the rule of law in this country is being undermined by very terrible ruling groups who are using this crisis to increase their power and control over the society, our society. So when governments fail to adhere to the concept called the rule of law, power rests not on objective standards, but on the will of those who hold the power. Rulers who disregard the rule of law do not exercise power under the law, but only by law. In this context, law is transformed into an instrument of repression, or at least top-down directions of subjects and nothing more. When this occurs, law becomes no more than a vehicle, and at times equally useful camouflage, for the exercise of unrestrained power. Since March 2020, Australians have passively watched their governments use a broad range of extra-constitutional measures to control almost every single aspect of our private lives. These governments have acquired so-called emergency powers that entitle public officials to detain citizens, search their premises without a warrant, close state borders, preventing even their own citizens from returning to their own homes, and force entire populations into unnecessary, counterproductive lockdowns, once this might be deemed necessary to protect so-called public health. With the financial support and even enablement of this Prime Minister that we have, the federal counterpart, the state premiers often express a desire to extend these extraordinary powers for a further period. We may be repeating history here, as the desire to extend emergency powers appear to confirm the worst feelings and fears of the Austrian-British economist and philosopher Friedrich von Hayek. In Law, Legislation and Liberty, this Nobel Prize laureate commented that emergency powers always seem to become eventually more permanent ones. Hayek offered this very sobering consideration. The conditions, and then he said, and I quote from Hayek, the conditions under which such emergency powers may be granted without creating the danger that they will be retained when the absolute necessity has passed are amongst the most difficult and important points a constitution must decide on. Emergencies have always the pretext on which the safeguards of individual liberty have been undermined. And once they are suspended, it's not difficult for anyone who has assumed such emergency powers to see it that the emergency must persist, must continue. This is not entirely dissimilar to what happened in 1930s in a particular country called Germany, where the government also turned to emergency powers into more permanent measures. This correlation between the instrument used by that particular German government in the 1930s to continue ruling arbitrarily and what the Australian political class is presently doing is quite frankly strikingly similar. This is evidenced by the constant renewal of these emergency powers that violate directly the rule of law and disregard the most elementary rights, fundamental rights of the citizen. It's particularly important in this context to be reminded of how dictatorial regimes are normally brought into existence. There is always an emergency which can be used to justify the violation of fundamental rights and freedoms. Of course, we are not comparing the current use of emergency power in this country with the use that was made of similar instruments in 1930s Germany. However, you argue that such instruments of extraordinary power have always facilitated the suppression of fundamental rights, while dramatically and drastically increasing the potentially quite dangerous power of the state. A brief elaboration of the events in Germany in the 1930s was appointed chancellor on January 30, 1933. The consolidation of the new regime was in no way assured. To add more legitimacy, the masses needed to be convinced of the necessity and, why not to say, the legality of measures that provided justification for further concentration of powers. Initially, the new regime took a strong interest in preserving the facade of legality. When emergency powers were enacted in March 1933, handing over extraordinary powers to the government for 4 years, temporary measures, everything appeared to have been done under the appearance of perfect legality. After all, the legal profession considered these measures perfectly legal, rationalizing that the use of emergency powers had been legally authorized by a 2/3 majority in the German parliament, as required by Article 76 of the German Constitution. The main characteristic of German lawyers in those days, who provided legitimacy to the Nazi regime, was their adherence to narrow legal positivism. They rationalized that if government requires its emergency powers in a legal manner, then the rule of law somehow would not have been violated, and whatever the government did was therefore perfectly legal. Those lawyers basically acted as apologists of an oppressive regime that alleged to be primarily concerned with the health of the German community. But that's the word used, by the way. After all, the German dictator once stated, the German leader stated, the health of the German nation is more important than the letter of the law. That was Hitler's statement. As a consequence, the reenactment of emergency powers in 1937, 1939, 1943 resulted in a schizophrenic combination of legal formalism with ruthless violence and the basic contempt for the rule of law. Ironically, the more those lawyers made efforts to legitimize the regime, the greater the contempt displayed towards them by the government. Under Article 48 of the Weimar Constitution, the German Constitution, the president could rule by decree with the aid of armed forces if public safety and health and order were seriously disturbed or threatened within the German Reich. That's the statement. And to the fact that he could, the leader, temporarily suspend whole or in part the fundamental rights of the citizens enumerated in the Constitution. As noted by German jurist Carl Schmitt in his influential political theology, written in 1922, once the emergency powers have been declared, the decision exempts the political authority from any normative restraint and renders to this person absolute power in the truest sense of the word. In a state of emergency, the constituted authority suspends the law on the basis of the right to protect society. That's Carl Schmitt, the legal philosopher of the Nazi regime. In February 1933, President Hindenburg appealed to emergency to sign a bill that suspended all constitutional rights, thus granting the National Cabinet authority to issue any directive as it was deemed necessary for the protection of the people. What followed was the suspension of constitutional rights until further notice. Of course, such further notice would not occur until May the 8th, 1945, when these emergency powers were finally cancelled by external military occupation of the country. Ultimately, the rise of totalitarianism in the 1930s in Europe cannot be considered an isolated fact, as some sort of accident. In those days, the Germans were quite willing and perhaps even anxious to be protected by a powerful government. They willingly renounced their own freedoms and preferred to be ruled by a benevolent ruler who would be good enough to protect them from any threat, of any real or imaginary threat. Of course, they paid a very heavy price for this. Their trusted in political rulers led the nation to a disastrous military conflict at the cost of 70 million people, 70 million deaths. Germany alone sustained 8 million losses, including 3 million civilians who died through massacres, executions, mass bombings, disease, and starvation. Obviously, it would be preposterous to sustain that Australia is facing similar fate. However, it can be stated confidently that the use of emergency powers undoubtedly facilitates the abuse of power and arbitrary measures that can profoundly undermine the rule of law and become more permanent over time. Australian governments are enacting measures that consolidate statism and allow informers to assist authorities in tracing and incarcerating people with warrants on the grounds of prospective conduct. Anyone in this country now can be arrested when the public authority assumes that they have failed to comply with health orders. As such, basic legal principles inherited from the common law and our tradition of constitutional government, including due process and the recourse to the writ of habeas corpus, have been considerably undermined. Australians have passively watched their elected representatives use a broad range of extra legal measures, and these politicians are appealing to emergency to impose draconian rules that deeply affect the enjoyment of fundamental rights. Under this context, governments can detain citizens who refuse or fail to comply with their orders. They will be detained by the authorities and no legal remedy will be made available to them. These extraordinary powers are arbitrary and extreme. They are a draconian attack on civil liberties, the like of which Australia has never seen before. Further, because all laws are overridden, there would appear to be little recourse to any access by an unauthorized officer or their civilians co-opted with them. These laws are so broad and ill-defined that you could be detained for almost everything or anything you do. And it's deeply disheartening to me to see so many Australians developing the mindset of slaves, to observe so many of them happily being patronizing others and speaking down to their own fellow citizens. Some of the worst aspects of this society have come to the fore through the panic buying, hysterical reporting dependency, and from some, a masochistic desire to obey and to take orders. This reminds me very much so of Benjamin Franklin, a leading figure in the early American history, who once stated, "Those who would give up essential liberty to purchase a little bit of safety deserve neither safety nor liberty." He was urging his compatriots to not give up of the basic, fundamental, inalienable rights and freedoms in exchange for a false sense of security. After all, as Thomas Jefferson famously stated, a government big enough to give everything you must or you want is strong enough to take everything you have. The Australian Constitution, in this context, must be interpreted according to its own purposes and values and principles, advancing the rule of law and the fundamental rights of every single citizen. To implement the rule of law and the ideas of constitutionalism, the Australian Constitution expressly limits the power of the state and the exercise of governmental powers. In drafting the Constitution, the framers deliberately aimed to create an instrument of government intended to distribute and limit the power of government. This distribution, limitation of powers, was intentionally chosen because of the proper understanding in history that unrestrained power is always dangerous and is always inimical to the achievement of human happiness and freedom. Anthony Gleeson, a former Chief Justice of the High Court, describes the Constitution's feature of express limitation of governmental powers as follows, and then I'm quoting from a former Chief Justice of the High Court, and I quote from him. "No one should be above the law. Thus, government officials must exercise their powers according to the law. If they do not, then, in the last resort, we, the High Court, may order and should order them to do so. The Constitution itself declares that the government must obey the law and gives the High Court the jurisdiction to compel such obedience. That jurisdiction cannot be removed or modified except by constitutional amendment, not by the use of emergency powers. Parliament, if acting within the limits of the powers assigned to it by the Constitution, may change the positive law, but the executive must always obey the law. Accordingly, the Constitution allocates the areas of legislative power to the Commonwealth primarily in sections 51 and 52, with these powers being variously concurrent and exclusive. The Constitution was amended in 1946 to add further provision in section 51, namely section 51, 23A. This provision determines, and I quote, that the Commonwealth Parliament can make laws with respect to the provision of pharmaceutical, sickness and hospital benefits, medical and dental services, but not so as to authorize any form of civil conscription. This provision allows for the granting of various services by the federal government, but not to the extent of authorizing any form of civil conscription. The concept of civil conscription was first considered by the High Court in 1949 in the British Medical Association and Commonwealth. In the opinion of Chief Justice of the day, Latham, civil conscription included not only legal compulsion to engage in specific conduct, but also the imposition of any duty whatsoever to perform any work in a particular way. Justice Williams went even further than that in his judgment, in my opinion, establishing an implied fundamental right, actually, when he said that the expression invalidates, and he didn't say federal legislation, he said the expression actually invalidates all legislation. which compels medical practitioners or dentists to provide any form of medical pharmaceutical service, she said. So the idea that constitutional provisions protect fundamental legal rights plays a prominent role in the understanding of the express limitations and indeed of the implied constitutional limitations which are derived from them. So accordingly, this no conscription requirement, which is found in this provision, amounts to an express limitation on mandating the provision of medical services. For example, compulsory vaccination, which remains governed by the contractual relationship between patients and doctors. Hence, as this section expressly does, it invalidates, and that's the words used by Justice Webb, all legislation which compels medical practitioners to provide any form of medical service, including vaccination. This constitutional provision couldn't be more clear. Subject to the validity of this conclusion, which is based on the existence of an implied constitutional limitation, even state legislatures, such as the state of Western Australia, could not mandate the vaccination of their citizens against the COVID-19 virus without violating the Australian Constitution. Hence, if the medical profession were directed by the federal government or state government to mandatorily vaccinate people, such direction would constitute an unconstitutional form of civil conscription. Such direction would interfere with the relationship between doctor and patient, a relationship which is based on contract and trust. Justice Webb explicitly stated, and I quote from Justice Webb in this case of the British Medical Association, when Parliament comes between patient and doctor and makes the lawful continuance of the relationship as such dependent upon a condition enforceable by punishment and fine, that the doctor should render the patient a sort of special service determined by the state, unless that service is waived by the patient, it creates a situation which is unconstitutional, since it amounts to a form of civil conscription. It couldn't be more clear. Justice Webb's statement indicates that no citizen in this country shall be in any way coerced into any medical treatment whatsoever, including vaccine. A medical treatment which is imposed upon a person without his or her informed consent is a trespass upon that person. In Bowater and Rowley, Lord Justice Scott explains what is required for consent, voluntary consent to be given, and I quote from this judge. A person cannot be said to be truly willing unless he or she is in a position to freely choose freely. And freedom of choice predicates not only full knowledge of the circumstances on which the exercise of choice is conditioned, so that he or she may be able to choose wisely, but in the absence of his or her mind of any feeling of restraint, so that nothing shall interfere with the freedom of this person's will. In 2009, in Wong and Commonwealth, Chief Justice Robert French and Justice Gamble held that civil conscription is a compulsion or coercion in the legal and practical sense to carry out some work or provide any sort of medical or pharmaceutical service. Justice Kirby opined that the purpose of prohibiting such conscription was to ensure that the relationship between medical doctor and patient was governed by contract, where there is the intention of the parties not being affected. Can I have a glass of water? Sorry for that. My apology. For Michael Kirby, thank you very much. For Michael Kirby, the test where the civil conscription has been imposed is whether the impugnant regulation, by its details and burdens, intrudes impermissibly into the private consensual arrangements between providers of medical service and the individual recipients of such medical or pharmaceutical services. This is supported by the Nuremberg Code, and I think Dr. Julie has mentioned this Nuremberg Code many times. It's an ethics code relied upon during the Nazi doctors' trials in Nuremberg in 1947. This code has as its first principle the willingness and informed consent by the individual to receive medical treatment or to participate in any form of experiment. This principle, in its relevant part, reads as follows. So I just quote from the Nuremberg principle now. The voluntary consent of the human subject is absolutely essential. This means that the person involved should have legal capacity to give consent. Should be so situated as to be able to exercise free power of choice without the intervention of any external element of force, fraud, deceit, duress, overreaching, or other ulterior form of constraint or coercion, and should have sufficient knowledge and comprehension of the elements of the subject matter involved as to enable the person to make an understanding and personally enlightened decision. People's refusal to be vaccinated may be based on the ground that COVID vaccines are still experimental, and the long-term effects and safety on its recipients are largely unknown. Indeed, the rule of law would be undermined if mandatory vaccination were mandated in such circumstances, where constant government changes undermine the confidence of the people in the efficient administration of the vaccine rollout, and to be more precise, even the effectiveness of these vaccines. Informed consent is actually the bedrock of the principle of ethical standards in medicine. Informed consent can be defined as voluntary agreement by an individual to a proposed medical or pharmaceutical treatment, given after sufficient and appropriate information about the potential risks and benefits, including possible adverse effects, how common they are, and what they should do about them. For free consent to be valid, the 10th edition of the Australian government's immunization handbook manipulation says, vaccines must be given voluntary in absence of undue process, coercion, or manipulation. This goes in accordance with Article 6 of the Universal Declaration of Bioethics and Human Rights that was, mind you, a declaration derived from the United Nations, which states, any preventive, diagnostic, and therapeutic medical intervention is only to be carried out with the prior, free, and informed consent of the person concerned, based on adequate information. For any government, either by itself or via corporate proxy, for instance, private enterprises, private companies, to attempt to mandate vaccines in such circumstances where the adequate testing and analysis of risks as well as benefits would constitute not only a violation of the principle of informed consent, but a violation of Australia's international obligations under the international human rights law with respect to medical experiment. Obviously, the vaccines on offer do not meet any final requirement of trust. Although trust is often based on misperception, a rational discussion might save the reputation of the vaccine company. But right now, even members of the medical fraternity are bewildered and do not know what to think. They disagree with regards to the advice they're given to their patients. Of course, non-government organizations and private companies are now requiring some of their employees to be vaccinated. Qantas even has gone to the extreme of offering inducements to flyers who are fully vaccinated, offering discount vouchers and opportunity to win valuable prizes. The governmental response to the spread of the virus certainly struck a blow at democracy and certainly undermining the rule of law in the process and confidence that the people have in vaccination processes. It has fatally compromised the enjoyment of rights and freedoms and wrecked the economies of the free world. In such an environment, it's no wonder that people have come to distrust the proposed remedy to the problem of COVID. Nevertheless, the undermining of the rule of law, resulting in egregious violations of civil fundamental rights of citizens, sits uncomfortably with the jurisprudence of the High Court. This jurisprudence indicates that the prohibition of civil conscription must be construed widely to invalidate any law which directly or indirectly mandates compulsory vaccinations. Above all, if governments cannot constitutionally enforce or force everyone to take the vaccine, they certainly cannot do it by indirect means, creating a situation where everyone would feel coerced or forced to take this vaccine. This point is also addressed in a very important decision by Justice Webb in the British Medical Association. I quote from Justice Webb now. If Parliament cannot lawfully do this by direct means, legal means, it cannot also lawfully do it indirectly by creating a situation as distinct from merely taking advantage of one, in which the individual is left with no other option, no other choice but having to comply. This is also mentioned in this decision, the Medical Association in 1949, they're the same. Furthermore, compulsory vaccination adversely affects the democratic principle of equality before the law. If unvaccinated Australians were to face serious restrictions of the rights and freedoms, for instance, being prohibited from going to restaurants or attending soccer matches or footy matches or whatever, that would be, nobody wants to watch soccer here anyway, because it's so bad. Let us use the analogy with footy. So what I have to say here is that compulsory vaccination affects the principle of equality before the law. If unvaccinated Australians were to face these restrictions of rights and freedoms, as suggested by medical officers, even these authoritarian prime ministers that we have, and state premiers who are equally authoritarian, this violates the democratic principle of equality before the law. According to the High Court in the decision of Lee and Comer of 1992, Justice Dean and Justice Tulhay refers to the preamble to the Constitution to support their own legal opinion that the principle of equality is actually embedded and implied in the Constitution. They argued that the essential or underlying theoretical equality of all persons under the law and before the courts is, and it has been, fundamental and generally a very beneficial doctrine of the common law tradition and the basic prescript of the administration of justice under our own system of government, constitutional parliamentary democracy. We don't want to have this being replaced by an elected dictatorship. That's what it's looking more now like. So the deliberate exclusion of unvaccinated citizens from participation in certain activities discriminates against them on the ground of vaccine status. Of course, vaccine status is not one of the accepted grounds in anti-discrimination laws. However, reliance on vaccine status creates an apartheid system, a situation that benefits some and will impose unreasonable and unlawful burdens on some other individuals. But more importantly, the making of coercive attempts to force people to get vaccinated would effectively amount to an indirect form of mandatory of vaccination, the constitutionality of which is doubtful at the best. Finally, it is worth approaching the matter from the perspective of human dignity and the privacy of individuals. Government should avoid relying on the parens patria, that's a Latin word, a term. It's a doctrine according to which government you decide what is good for you. It would be a textbook example of the operation of the nanny state that removes from the person any sense of individual responsibility, and even, certainly so, human dignity. In fact, such governmental approach violates even international law, and it certainly contradicts the Declaration of Human Rights from 1946. Paternal rulers disregard personal choices on the grounds of promoting their own good, the good of the people. Such attitude involves an authoritarian paternalistic behavior, which is always very dangerous. It reveals an attitude of superiority. They think that they are somehow better than you. That's why Madame asks you to send a Happy Father's Day card to him. Yeah. Happy Dad's Day, Happy Father's Day to him. So there is a danger of excess. Of course, he expects you to do much more than that, even to serve him as if you were. There is a danger of excessive state paternalism when citizens are not allowed to make personal decisions about their own medical treatment. This was highlighted in Airedale National Health Service in Bland, when Lord Justice Mustill expounded on this danger with the following clarity, then I quote from another judge again. If the patient is capable of making a decision on whether to permit treatment and decides to not permit it, it is his choice that must be obeyed. Even if one on any objective view, it is contrary to his best interests. A doctor has no right to proceed in the face of objection, even if it's plain to all, including the patient, that adverse consequences and even death could ensue. So not even that. The doctor cannot impose medical treatment on patients according to Justice Mustill, and certainly not the government for that matter. John Locke was the greatest, I would say, father of constitutionalism. He was a source of inspiration for American founding fathers when they drafted the American Declaration of Independence. Certainly he was the main mentor, the inspiration, or the justification, I would say, through his work, the Civil Treatise on Civil Government, of the Glorious Revolution in 1688 and the Bill of Rights of 1689. John Locke believed that one of the greatest mistakes a society can ever commit is to confound paternal power with the power of the state. Indeed, his primary goal was precisely to separate governmental power from paternal power. In other words, to deny the existence of any valid analogy between the relationship between a father and a mother, for that matter, and a child, as per the relationship between government and citizen. However, listening to the paternalistic behavior of McGowan, and also, I must say, every single other, complicated characters that we have in power, C.S. Lewis put this point very clearly here. Of all tyrannies, a tyranny is sincerely exercised for the so-called good of its victims may be the most oppressive of all. Those who torment us for our own good, you torment us without end, for they do so with the approval of their conscience. I would have more things to say, but I want to bring this to a conclusion, then we can have some questions and a bit more of interaction. So the Australian Constitution must always be interpreted in a manner that promotes its purposes, values, and principles. It must advance the rule of law, and in doing so, we must have our fundamental rights and freedoms, which are protected by the Constitution, guaranteed, and should never allow governments to take away what has not been given by them, but in my opinion, has been given by God. These are the inalienable rights of the citizens: the right to life, liberty, and property. Indirectly forcing vaccination under the threat of losing rights is not voluntary consent. And when a citizen's enjoyment of rights become limited as a punishment for refusal, the consent's made definitely under duress. It is, in effect, a form of constitutionally valid coercion. We should not allow this to happen. It was a famous Irish politician. Since I have mentioned a famous English political philosopher, I want to place my Irish constituency now. It was an Irish politician, lawyer, and judge, John Curran, the greatest people's advocate of the 18th century, who once stated, "The condition upon which God has given liberty to man is eternal vigilance, which condition, if he breaks, servitude is at once the consequence of his crime and the punishment of his guilt." Unless we finally start to be more vigilant in this country and develop a better sense of self-respect and dignity, our country is just about to irreversibly descend into a less open or more disguised form of elected dictatorship. We should speak this to our friends, talk to others, and let them know that the price of liberty indeed is eternal vigilance. And you should now be more vigilant than ever. Promote the values that brought us to prosperity. And if you cut the trunk that leads to the fruits of the prosperity, do not expect that you are going to have them in the future. And you'll be held accountable by the future generations for the rights and freedoms that they have lost. But this is not going to happen because we are now vigilant. Yes. And you fight the good fight for freedom, and with God, all things are possible. Thank you very much for that.
Okay, so we've got some written questions here, and then we'll take questions from the floor. This is your first question, and this is in reference to section 51 of the Constitution. How is this section of the Constitution not protecting us to have the right to consent to medical services at a state level? Should the state governments, not just the federal, have to abide by the Constitution as we are all one country? If this and section 109 doesn't protect us, then we have no hope, and state premiers can make rogue decisions with no constitutional consideration. 51 and 109.
So there's important questions. Section 51 is called it's a provision in the Constitution allocating powers to both Commonwealth and states. It's actually called concurrent power. So everything you find in Section 51 in theory should be possible to be legislated by both state and Commonwealth. The person referred to also another section called 109, and that 109 is about inconsistency, which says basically that since we have concurrent powers in Section 51, if there is a clash between federal law and state law, the federal law prevails at the extent of the inconsistency. But I always say to my students, because I think that one of the vehicles per excellence of authoritarian regimes is concentration of powers. And over the years, the High Court has done a very terrible job to concentrate more powers in Canberra. So I always say that Section 109 has to be interpreted in the context of the continuing power of the states. So you should not allow the Commonwealth, or have allowed the Commonwealth to increase its powers. when there is another clear provision in the Constitution saying that the powers that had not been given to the Commonwealth should not have been transferred to the central level of government. But if both provisions are constitutionally valid, and if the Commonwealth provision clashes with the state provision, then the Constitution is very clear that the federal law must prevail at the extent of it. So I think this question helps to understand how oppressive, how much the source of oppression, comes from the federal government. So actually, this dictator that you have in Western Australia, this little tyrant, he wouldn't be able to do this sort of behave in such an arrogant manner. I find it unbelievable how people like him, because he behaves in such a despicable way. I can't stand this sort of arrogance. I'm a free citizen, so I don't like to be treated like that. But I can tell you one thing: the Prime Minister is very much to be blamed. So I blame the Liberals as much as I blame Labour. I have a terrible thing in my past. I used to be the vice president of the Liberal Party. I have to publicly apologize. And I even wrote a letter of resignation that has been put in the Spectator, saying that I really feel ashamed of that. And I had to resign because it is a matter of preserving my image and reputation. If I remain the Liberal Party, I would damage my image and my reputation.
Well, my confession is in 1970 something or other, I campaigned for Gough Whitlam. So we all have skeletons. Okay, another question. South Australians, so this is about this situation in South Australia, are being advised that they are to download an app that combines facial recognition and geolocation. Does this breach the Privacy Act, which would override any state act or direction under Section 109 of the Constitution?
Yes, and that's exactly the point that led me to give the example of a different country in a different era, basically a different jurisdiction. And these emergency measures are basically being used to justify the undermining of constitutional provisions. And unfortunately, the High Court, when I mention all these excellent judges who made good decisions, they are no longer members of the bench. They are not on the bench. So also, our High Court, that's how we call the highest court of the land. In America, it's called Supreme Court. Here it's called High Court. The High Court of Australia has made very strange decisions more recently. Even to the point of saying that, for instance, just give one, the Love case, that the person who feels or identifies himself as an Aborigine, even if he has committed murder or raped a person, he can stay in the country because he identifies himself with the land. I mean, he's not an Aborigine, but he feels as he is. And then the High Court told, oh, that's fine, then you can stay, even if you are a murderer or a rapist. And then you have Section 92 of the Constitution. So if you think the courts are going to help you, they are part of the establishment. Yeah. And I can tell you, in the past, the politicians were more discreet because they upheld liberal values, and they really had a concern for fundamental rights and things. But I don't think this new generation has the same sort of appreciation for the rule of law and for the protection of individual rights and inalienable rights of the individual. So I'm really concerned about expecting that others will do what we should do by ourselves. So I will publish in Quadrant magazine a very daring statement together with the leading constitutional law professor in this country, Emeritus Professor Gabriel Moyes, the recipient of the Order of Australia last year for excellence in legal education. As I say, I have to repeat, the leading constitutional lawyer in this country is going to create a case for disobeying unjust law, and certainly there is a case for lawful right to disobey laws that violate the highest law. So if you have, we can actually have a legal argument, disobey laws that are actually a violation of fundamental principles derived from the rule of law. So first of all, I'll have to explain what the rule of law means, and I have to explain our constitutional rights and traditions, and then explain that there is a higher hierarchy of laws. And that there are laws that don't fulfill the purpose of the law, that is to advance the common good and protect the rights of the individual. If laws are used as an instrument of oppression, it's just how you call them, but they're actually measures that are used to remove the protections that were found in the common law tradition and that are inalienable of the individual and should be upheld by the courts, but we never know what can happen, and we should pray and hope that they might do the right thing, but that's not necessarily the case.
Okay. Another question. We got a few more here. How can bills be allowed to go? Is this working? Can you hear me?
Yeah.
How can bills be allowed to go past the first reading in Parliament if they breach the Constitution?
Yeah.
Well, that presupposes that the political class is concerned about upholding the rule of law. So I know that some politicians have no such concern, because when I was the senior vice president of that party that I prefer not to refer to the name by name, but I was very disappointed with the behavior of the political class. Some of them really clearly, objectively hate the people of this country. That's why they created so-called anti-discrimination laws that are basically anti-free speech legislation. And you have some people who actually have a concern against, to fight against racism, for instance. And they have become the victims of the legislation because they happen to be belong to an ethnicity that should not have the same rights. So this person is Caucasian, and he attended a lab that was reserved for people of a different color of skin. And when he complained, it is a very reasonable complaint, he said, it's funny that this university is fighting discrimination with more discrimination by excluding me from the lab on racial grounds. Now, he got into trouble, it was the other way around. So now we have laws that, in theory, to protect us from racism, being used to persecute people who are fighting against it. So we have many other, for instance, in Victoria, they have the Religious Tolerance Act, that is a form of blasphemy law by stealth. And it was used by the Muslim community to be persecuting people from different religions. So these laws, rather than being an instrument of tolerance, they are instruments of bigotry, to be used by bigots to silence the debate, to prohibit people from expressing different ideas. I don't think it is an accidental thing. My conversation with these people lead me to the understanding that they are not so stupid, but they are advancing an agenda, and they want to suppress your freedoms. I find it surprising that they can say the most appalling things in Parliament, and to be very rude even, but they are not allowing you, the sovereign people of this country, who ultimately they have to give an account to, because they work for you. And so you have not the employee thinking that they're more important than the employees. So we have put them to power. We have to actually tell them that enough is enough, and they have to restore all the rights and freedoms that they have stolen from us.
So would you conclude then the reason that they continue past the first reading is because they have a nefarious agenda, and therefore they don't care, they'll violate.
And they are confident that their counterparts in the judiciary will be silent on these violations. Think about that. Our system has not been thoroughly good, but we used to have what I described in my PhD thesis, the culture of legality, the culture of constitutionalism. Because there are serious flaws with our system that I prefer to not explain now, but we used to make it work. Because more important for the achievement of the rule of law is people who want to make things happen according to law. So even if the system is not perfect, you would aspire to make it work even better than it could potentially be. For instance, the Governor General, it means the government, or do other things that apparently give him even dictatorial powers. I always explain to my students at Murdoch, to teach constitutional law with them, that if we exported this constitution to some other countries, including our neighboring country, our neighbors here, Indonesia, probably they would turn this into a dictatorship because the governor general is so powerful. But why he doesn't exercise this dictatorial powers? That's because of our conventions. We have a Westminster system that restrains his actions. To the point now that we have realized that he does nothing actually, because the governor general is actually now basically serving for nothing. So that's one of the flaws with the system. Another thing is that we unfortunately have crooked politicians appointing their mates to the judiciary.
Yeah.
It's inappropriate for the political establishment, the parasitical oligarchy in parliament to actually choose judges. I mean, this person will probably have to compromise so much in order to be appointed that he's not going to protect us from tyranny. We should have judges having to be, in order to be appointed, lawyers having to sit exam, public examination. And they will have to pass the exam in order to be appointed. We should not have politicians appointing judges anymore.
Okay, how are amendments to current acts and these directions passed? Do they have to go through a parliamentary process?
Well, there are some committees in Parliament, as normally, as you know, this is also based on appointments coming from all members of the political parties. And, so the point is that in order to be a member of this commission and even to be a minister, you actually have to be a member of Parliament. So rather than choosing people on the grounds of merit, you would expect that the Attorney General would be a good lawyer, not a politician who happens to be appointed by his mates. So the point that I see is that somehow we end up choosing the worst people for these jobs. Why is that? Because the person who is more narcissistic, thirsty for power, that is the guy who has a better chance to become the premier. Because he's the head of the criminal organization. You know? So if you're run by a mafia, the leader of the party is actually the head of the criminal organization. It's as simple as that. We should perhaps think about what went wrong in America, but certainly it might be a good idea to think about having the head of government elected by the people. I think it works better. And to have more checks and balances, because one of the things that lead to tyranny is when the powers are not separated properly. If you have a judge being appointed politician, the executive not separated from the legislature, everything is looking dangerous here. And Montesquieu said that one of the reasons why you can have tyranny and oppression is when the powers of the state are not properly separated. And that's not happening at this moment.
Okay, we have one here on, this is on WA government. They're forcing vaccination on healthcare workers under the, under what's the papers here, it's under the Public Health Act. Has everyone read the Public Health Act 2016? If you haven't read it, make sure you do it in the morning because you won't sleep at night. Does this act not contradict the Biosecurity Act, which would not be allowed under Section 109 of the Constitution, rendering the WA Health Act and the attached? Okay, they're the public health orders, the directions, would render them invalid. Would the WA government not have to issue a human biosecurity control order to every individual? Or is there a loophole somewhere that makes these draconian directions legal?
Yes, as I have mentioned in this paper, when you have a construed emergency, these powers are used in disregard of the existing constitutional protections. So that's the excuse given by the rulers to say that these are only temporary measures. But certainly if there is a clash between federal law and state law, that's why perhaps Section 190 even applies in this case, perhaps in a better way, because certainly if you can prove to me as a constitutional lawyer that there is so-called, not even so, there is an existing clash between this federal act and an act of the state parliament, then certainly 109 must be triggered. So this is something the judge should have to do it, and I find it quite unbelievable that somehow they have a regard now for the empowerment of the states, because they have never had any consideration for state rights. In the past, which we had, it was the government in Canberra concentrating each day more power, and regardless of the constitution guaranteeing that the powers of the state should have to continue. And that's in 106 and 107 of the Constitution. They have never been advocates for state rights. But when it comes to have the state violating fundamental rights and freedoms, they have finally discovered that for this purpose, the states can have plenty of power and rights. So it's very disappointing that they have discovered federalism, not for democratic means, but as a means of oppression and tyranny.
Okay, here's another one. My partner is from New Zealand. He is under the impression that as he is not a permanent resident or citizen of Australia, that he is not protected by the Australian Constitution. He holds a certain class visa and has been here for 17 years. So is that correct? I assume that meaning not protected by the Australian Constitution.
Well, I don't know his status, whether he is at this point, he's certainly a permanent resident. Being here for such a long time here, it's just not a citizen. There's very little difference between permanent residents and citizens. Basically, the main difference is that citizens can vote and have political rights. But he's not going to have any other rights and even privileges removed from them as a result, or basically even the obligations. So that works both ways. You have to have the same rights and duties that any other person living in this country would have.
How about non-permanent residents? Like there are English people living in Australia who never take Australian citizenship.
But they are considered to be the law in the past would consider a British citizen to have at least the right to be treated as a permanent resident in this country. Yeah.
Okay, so questions from the floor. So the way we're going to do this, I'm going to run around and you're going to ask the questions. You first. You had your hand up here, someone here, so next.
Hello, my name's Simon. You spent a good deal of time at the beginning mapping out the state of emergency situation and how that seemed to be, in my simple mind, the primary mechanism by which the authorities can run roughshod over the Constitution. So my question is, where there hasn't been a state of emergency declared, how is it possible for example, employers or any other category of folk to demand that there's a need for mandatory injections? I would have thought that's just straight up a contravention of the fundamentals of our Constitution.
Yeah,
that doesn't seem to be the case.
Yeah, absolutely. And you see the messages that are being conveyed, especially by Scott Morrison, the Prime Minister. Basically, what they're saying is that not directly forcing them to take such measures, but they are being under pressure to take such measures. So some employers are now feeling that they have to do that in order to be having their business reopened. In Sydney, it's happening a lot with people, the whole community being under such terrible pressure now to be vaccinated. That is, according to Justice Webb, an indirect form of coercion, and it would not be acceptable to be done even by indirect means. So the government might directly force you to do something that is quite more visible and clear. But according to my understanding of the jurisprudence of the High Court, even this sort of pressure that the Prime Minister is exercising on employers is actually unacceptable from a constitutional law perspective. But if the person is being forced by the employer to be vaccinated, it's certainly, in my opinion, as a constitutional lawyer, completely unconstitutional but I'm not an employment relations law where the practicality of how you have to fight against this can be done, because one of the best things about being an academic is to not have to be a legal practitioner. So I'm not a legal practitioner, I don't like it. I like to change the things that are wrong. I like to be the great thinker, not to have to be a legal practitioner. But I think you need to have an employment relations law in this situation such as this, and even threaten the employer of liability. Because let's say that if you get sick as a result of the vaccine, you have to be civilly liable for any damage that can be caused as a result of you taking the vaccine. By the way, certainly made under duress if you receive, for instance, a communication whereby you have to take the vaccine until a certain period of time on the grounds that if you don't do so, your job will be terminated. If you receive such a letter, you should immediately talk to an employment relations lawyer, and certainly this is clearly a breach of the contractual relationship between employer and employee. Before you got the job, you got the terms of the employment contract given to you for you to sign. These terms cannot be changed unilaterally without the consent of both employer and employee. You have to have the consent of both. If the employer forces you to get vaccinated, you definitely should procure or seek the advice of a proper employment relations lawyer, because that seems to be a breach of the employment contractual term.
And beyond that, I mean, I'm not an employee, but just quickly again, there seems to be some fundamental other breaches by our top level politicians.
Absolutely.
And I'm interested in how they can be pursued legally on a personal basis,
Yeah.
i.e. you're facing execution, jail time, treason.
Yeah.
That's tantamount to...
Well, let's hope that this can happen in the future, but that would require as much political action as it is a legal one. So for us to restore the rule of law, this is going to be as much a social, cultural, political achievement as it is a legal, institutional one. I don't think the institutions will do it for you. You have to do it for yourself. I think we have to ultimately severely punish these politicians. And I would hope that in the future they will have definitely to at least have to find another job and hopefully going to jail for the crimes they have committed.
And maybe we can fill the courts with all those unfair dismissal cases that we go on for 1 million years.
Like me.
Oh, okay. Next, down here.
Yes, I believe that I've found the solution to all of this. Do you mind if I present it?
That's right.
I believe that the Chief Health Officer, Dr. Andrew Robertson, who wrote the health worker restrictions on access directions, knows that these directions are unlawful and has admitted that in the directions themselves, and that paragraph 7 exempts all health workers from all the directions. Can I read them?
Please.
Paragraph 7 reads, nothing in these directions, the first 6 paragraphs go on about the mandatory vaccination. Then paragraph 7 turns around and says, nothing in these directions prevents a person who is not vaccinated against COVID-19 from entering any part of a healthcare facility for the purposes of performing, and there are 5 purposes listed. A, performing a law enforcement function that cannot reasonably be performed other than by entering healthcare facility, referring to police officers. B, performing a statutory duty arising under a written law of the Commonwealth that cannot reasonably be performed other than by entering the healthcare facility. Healthcare workers have a statutory duty to provide patient care. Therefore, all health workers are exempt from mandatory vaccination. C, performing any function or duty or exercising any right or power under a Fair Work entry permit issued by the Fair Work Commission under the Fair Work Act 2009, which is a Commonwealth law, or a Work Health and Safety entry permit issued by the Fair Work Commission under the Health and Safety Act of 2011, which is also a Commonwealth law. And these are two Commonwealth laws that these directions violate directly.
Yes. Yeah.
D, responding to an emergency in a capacity other than as a health care worker or health support worker, which refers to police and fire services. And E, providing emergency care to a patient in the healthcare facility where the emergency care is necessary to be provided immediately, and a fully vaccinated or partially vaccinated healthcare or healthcare worker or health support worker is not available to provide that emergency care. And the conclusion of paragraph 7 states, and to the extent that a healthcare worker or a health support worker enters a healthcare facility for any of the purposes in a care facility for that purpose, irrespective of whether that person appears in column 2 tables anyway, which means no matter what function they serve or at the healthcare facility. And so my question is, I would like to take this to the higher court to have all of these mandates abolished and all COVID restrictions ended. Would you support me in that?
Once again, I have to tell you that one thing is what the law ought to be, and the other is how it's going to be applied. So you still believe in the system, you'll say, because what you're reading to me is a very clear evidence that they are violating these very clear legal determinations. And we are having the false expectancy or expectation that these people really care about this. Yeah. So to be frank with you, I am not a believer in the system anymore. And I think everything that you're saying is your right, but it's not going to be enforced, perhaps even by the courts in this day and age. So the only way to go is perhaps to appeal to something more transcendental, which is your lawful right to resist. So what I tell you is that do not think that the system is unaware of the instances of oppression that are now being exercised by them. It's wishful thinking that they don't know what they're doing. So the right to disobey, can I read the passage that I couldn't because we didn't have time, but it's about your right to disobey. The right to disobey government directives that violate fundamental freedoms constitute an old tradition in Western legal philosophy. And I am a legal philosopher, so I cannot resist the temptation to refer to it. For example, a sound doctrine of resistance to arbitrary government was developed in the 17th century by Samuel Rutherford in his book Lex Rex. He explained that the political power, whenever it is used to oppress, is not lawful, but instead is a licentious deviation of a lawful power. These views were also expressed by St. Thomas Aquinas, whose analysis amounts to a prescription for controlled government, providing a rational basis on which to affirm that there are limits to what the state can rightly do. St. Thomas Aquinas' insistence that the power of the human law may be limited implies a right to of the person to not be subject to unjust law. According to Aquinas, a person is bound to obey rulers insofar as this is required by the order of justice. Therefore, if the political ruler commands what is unjust, his subjects are not bound to obey him, except perhaps accidentally, in order to avoid any sort of a scandal or danger. Ultimately, St. Thomas Aquinas commented, if it is a people's right to provide itself with a political ruler, and if that ruler tyrannically abuses of his power, there is no injustice if the community deposes or checks him whom they have raised to the government, nor can it be charged with a breach of faith or abandoning a tyrant, even if the people had previously bound themselves to him. Because conducting himself as the public God, he has brought it on himself, and his subjects must renounce the bargain with him. John Locke played, as I mentioned, a fundamental role in the development of modern constitutionalism, established that no government has any legitimacy to undermine inalienable rights to life, liberty, and property. As Locke stated, that's the father of modern constitutionalism stating, and I'm quoting from John Locke now. The person who justified through his writings the actions of those who brought about the Boer Revolution in England in 1689. Whenever the legislators endeavor to take away and destroy the rights of the people, their basic rights to life, liberty, and property, or to reduce them to slavery under arbitrary power, they put themselves into a state of war with the people, who are thereupon absolved from any further obedience, and are left to the common refuge which God has provided for everyone against force and violence. End of quote. The American founders relied on Locke's phraseology to draft their 1776 Declaration of Independence, which evokes a long train of abuses and the consent of the governed as the primary basis for resistance against arbitrary government. Drawing heavily on Locke's philosophy, the American Declaration assumes the preeminence of the law of nature, which prohibits any government to violate these inalienable rights. Curiously, the same declaration concludes that, and I quote from the declaration, whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute a new form of government. The practice of civil disobedience can be described as the violation of unjust law promulgated by the recognized governmental authority. The International Covenant on Civil and Political Rights does not mention civil disobedience directly as a potential right to resist governmental oppression, although it could be reasonably stated that some acts of disobedience are effectively protected by this international treaty. Articles 18 and 19 of that international legal instrument. Under Article 19, for instance, everyone shall have the right to freedom of expression. And as stated by Article 18, everyone shall have the right to freedom of thought, freedom of conscience, and freedom of movement. In an essay on civil disobedience, Professor Gabriel Moyes, the former law dean at Murdoch University, my great friend, and also former provost chancellor at Murdoch, argues that civil disobedience becomes an option when the normal channels of social change do no longer function properly anymore, or whenever serious grievances are not heard. A system does not function adequately anymore when some groups have entrenched power positions in society and use their powers to impose their will on weaker and more vulnerable people. That's Professor Zimmermann's statement, the leading constitutional law professor talking about the right of civil disobedience in such cases. It's possible, therefore, to argue that citizens are morally and lawfully justified to disobey legislative commands that are incompatible with the well-known principles of the rule of law, which are also derived from our traditions of constitutional government. Assume, for instance, that the people find themselves in the uncomfortable situation of having to break a law in order to preserve their fundamental rights and freedoms. In such situation, the need of government to respect our freedoms of association, movement, speech, and thought implies a natural right of the citizen to breach these rules which are inconsistent with the ordinary exercise of these freedoms. Civil disobedience may therefore manifest itself as a valid, lawful means to disobey arbitrary directives that constitute an intolerable violation of our fundamental rights. Although such acts of civil disobedience should be non-violent, we must never ignore the fact that oppressive measures that result in gross violation of fundamental rights are themselves a form of violence. And since people are more naturally inclined to disobey rules which they personally disagree, any recourse to civil disobedience should always be balanced against the important principle of regular obedience to validly enacted laws. It goes without saying that the political system does not function adequately when some privileged groups become an entrenched oligarchy that imposes arbitrary and voluntaristic measures on more vulnerable members of a society. Whenever the normal channels of change have ceased to function properly and serious grievances by the people are not satisfied by the entrenched ruling class, civil disobedience then becomes a morally valid and more effective way to alter the undesirable status quo. As a strong medicine to render the political establishment more responsive to popular grievances, reliance on civil disobedience requires a long sequence of human rights abuses and should be followed by popular mobilization and widespread popular support. And that's actually something that is in accordance with our very traditions. And the person who would morally and lawfully justify this are our own founding fathers. Thank you very much.
I'm very nervous. Obviously, we all come here for the common good, for our freedom of speech and movement and our rights and stuff like that. Okay. So what I'm trying to say is, like you said, we have freedom of movement, freedom of speech, but we can all see that Monica Smith, Reignite Australia, is in jail as a political prisoner because she won't do a PCR test, and you know she's been jailed illegally, really, because she's speaking out and going to the marches to report as a journalist, as she is. I would hope that we've seen you go around and talk in the same manner. She's doing it on the internet, you're doing it at meetings.
The internet as well.
Yes, but
Go to my Facebook, you will see.
well, actually, I just turned Facebook off today, so I can't, unfortunately. But I'd like to know, what have you got in store for going around and talking to the people of the common good and encouraging us to fight for our rights?
Yeah.
How are you protecting yourself? Because we would hate to see...
I have a second passport. That's the one. I hope I can use the ones I
Augusto, it's a good question though, because
Yeah, it is an excellent question. I must say that because we need to have a little bit of humor here because this is so terrible. So I'm just trying to see if we can have a little bit of a happier atmosphere. But it can be quite exciting to be living in a time such as this, you know. In many ways, this is something that can give meaning to your life. So now is the time to really think about something much, much better and beyond material comfort. Now we'll be revolutionaries for freedom and human rights. That's our chance to make history.
Absolutely.
Thank you.
I asked Andrea Takaji, who's doing her PhD with Professor Zimmermann, this question because obviously some of us post online and the laws in Australia can be extraterritorial, is that right? Is that the word you used? So even if we posted lawfully in Western Australia, we actually could be guilty of incitement in Victoria. And she said, yes, that is the case. So that goes to this point, what you're making. We need to be willing to give up our lives. If we're really serious about this, then that's.
And you talk, the person who is talking to you is a man who I have a profound admiration. Because John Hartnett is one of the most prominent physicians in this country.
Physicists.
Physicist. Sorry. Then you say English is my second name, I can give you this. So he's a physicist. And then he's a professor, a very eminent professor at UWA. And I have always had a profound respect and admiration for you, John. And the fact that you're actually saying these things just gives me confidence and the certainty that this is something that God expects of us. So I think with God, all things are possible. And this is going to be done for his honor and glory. Thank you very much for that. And I will continue to support everybody here in this cause that is just and right. And I hope, God willing, that we can save this country from these oppressive measures that are going to destroy us. Nothing is done. But we will be doing, and you'll be resisting. This is the beginning of something that will give a change of direction to this country, that you're going to make history indeed. I just want to be with you on this journey. I am very upset because I thought I would come here just to have a very comfortable life, but they are not allowing me to do so because of a conscience. And I cannot allow these people to do these sort of things to you. I will do everything I can at my disposal to fight for the freedoms that you deserve to have. Thank you very
much. Just curious, you've talked about mostly things that have been written by judges, etc., and that have shown that within the Constitution there are things that either are implied or are written and stated as this is how it should be.
Yeah.
We aren't taught any of these things. We don't know these things. Do you think that perhaps we need to go to a stage where, like the Americans, we have a Bill of Rights, or like the Canadians' Charter of Freedoms and Rights? Do you think we need to start looking at doing something like that? To take those things, not to add to it, but just to show those things that are in the Constitution and what they mean to us and how we can apply it in our lives and force them on government.
It's certainly very important to educate or even our children at this point, because I have 2 children, and if it were not for my own instruction, they would probably only know how to perhaps hug trees, or I think the Japanese are very evil because they eat whales or something like that. But they have no knowledge of history whatsoever. That's deliberate. The Liberal Party must be blamed for that because they had the chance to get rid of this national curriculum. And I had to write about the national curriculum. It's total indoctrination. Even to the point that was written by a former member of the Communist Party, a professor who happens to be a proud communist. But the funny thing about being a proud communist is that he hides all the crimes committed by the communists. There is nothing there about Stalin killing 40 million of his own people, or Mao Zedong probably killing even more, like 60 million people. So all the crimes and atrocities committed by socialist regimes, apart from the Nazis who happen to be National Socialists, all the other socialist regimes, they are not even mentioned in this national curriculum. It seems that for the children in this country, the concept of human rights was not derived from the traditions of the Magna Carta or the Bill of Rights or the American Independence, but from the United Nations. And that's what they say in the national curriculum. So it's no wonder that people don't know their rights, because they're being brainwashed and they are dumped down by our educational system.
Augusto, I think you should plug your course on constitutional law at this point.
Yeah, well, I have to teach presidential lectures because Sheridan wants to be very conservative. I'm trying to open even a law school now at Sheridan. It's a Baptist education provider in order to set up the first Protestant university in this country. And I'm in charge of the areas of law and politics. I'm actually teaching this trimester Foundations of Constitutional Government. I will be teaching again next year, and my next teaching trimester 1 next year is on Introduction to Australian Legal System. So if you want to know more about what I have to say, I would absolutely love to be with you in this journey. And I promise you that I'm not going to disappoint. Thank you. Yes.
Hi,
Hi.
I'm all for the right to disobey and your right to disobey and civil disobedience. However, 300,000 people were viewing online the Holcroft versus Hazard, and there are these cases that are almost going to set a precedent in our country, which is going to make everybody so vulnerable as to this lawful intervention. So what are you following, and how, obviously I would imagine you would be, and what are your thoughts on this for a wider perspective for the Australian public?
I think it's very important, and I have been helping some of these solicitors and barristers, including those involved with the. I also have to. The reason is to be that I decided to be an academic is that then I can speak the truth. I'm not a barrister. I'm not so I can speak truth to power, and I think that in many ways you might be doing the wrong thing by constantly seeking the courts now, because they are not as good as they used to be, and they will probably, if they disregard even the Constitution, guess what they're going to do with precedent that's even less important than the Constitution. So common law is based on judge law, decisions made by judges, but ultimately the most important law of the land is actually the Constitution of the Commonwealth of Australia. If these judges have no respect even for the Constitution, imagine then if they're going to have any regard for what I have written here. There will be even less considerable of these determinations that were made by past and far more decent and competent judges. So the point is, I feel that it's quite dangerous sometimes to go to the courts because it's very expensive in the first place. And I think some people might even have gone bankrupt as a result. I'm sure of that. There is no access to justice in Australia. Australia lacks in the rule of law because you have to be either very, 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 very poor, or you can have lots of money, be very, 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 very rich. Then you can have some lawyers to help you. But if you are middle class, it's very hard to be engaged in a legal battle because the costs of litigation in Australia are imperative and makes it impossible for some people to redress the injustices that are committed. So I think that one of the things we should do when we start electing decent politicians, not the crooked ones that we have, is to allow the system to actually be more democratic so that people can actually have access to justice rather than being receiving this financial impediment as a result of not having enough financial capabilities. But going back to your point that's so important is that indeed in the common law system you have the tradition of binding precedent. So if the judges start to create these decisions that are serving the elites, they are going to do something that reminds me of the role of the judges in Germany in the 1930s, when they started to say that because they were under emergency powers, everything the government was doing was therefore legally acceptable and legally valid. They're going to give a rational so-called justification for all the tyranny and oppression that is being envisaged upon us. Do not trust the judges in this country because I know them enough to never be so optimistic. I think some people who are thinking that the courts will help them, they are ultimately going to become very disappointed.
Since paragraph 7 of these directions clearly deems all health workers to be exempt persons, our managers are obliged to honour our exemption. What must we do to hold them to that obligation?
Well, there is the avenue, the legal one. You can have all these people seeking the assistance of an employment relations lawyer, and then you could have perhaps the lodgement of a class action. And of course, if I were the judge, I would give cause to you. And it's a fair work system. But as I say, I have learned to never be overtly optimistic about outcomes. So even if you think that you have a good cause, I have seen people have excellent cause and they somehow mysteriously lost the case. Now sometimes it's very compelling and they lose the case. So even though you're appealing to all these things, they can always appeal to emergency measures. So the point with the problem, the thing that's happening is that any sort of measure can be ultimately justified on the grounds that we are in a temporary situation. It's urgent, emergency powers, all these things, and that has always been used to undermine fundamental legal rights. So you're appealing to your right, but that's the rights themselves that are always removed when they use this excuse of emergency. So being under emergency, they can actually disregard and ultimately disobey even very clear provisions derived from acts of parliament themselves. So basically what I have to say as well is that, that some of these members of the legal profession are going on the basis of their own legal positivism, say that whatever the government does is inevitably somehow legal because they see the law as something that is invariably enacted by the political ruling elite with somehow the tacit agreement of the judicial elite. So that's called legal positivism. And most legal practitioners in this country, because they have no jurisprudential training, they have no idea whatsoever of jurisprudence. They have never learned common law history. They don't even know legal history. So we are in big trouble because 99% of the legal profession is comprised by people who are not common lawyers. They have no idea what it means. I was speaking Greek to them, and I have to have lots of patience because sometimes I just feel that the worst thing is when you have a person who knows nothing and can be quite arrogant at the same time.
Yeah.
Hi. So healthcare workers are going to have to pay $20,000 if they do not work on the day after D-Day. Just wondering where healthcare workers stand with regards to this, and they're threatening that employment gets terminated.
Look, I can refer you and others to some people you can trust. There is a lawyer who is helping my work, and he's at his labor law. His name is Steve Heathcote. Yeah, he's a great guy. So I really think you should talk to him, and he'll pray for you.
Is the best thing for the healthcare workers to just strike en masse? To bring that point?
Yeah, I think this is the best solution. I have told many people that if the masses are mobilized, if people start to be more conscious of their rights, then it's very hard for you as an isolated individual to do anything because that's when the oppressive totalitarian regime target you. But if there are thousands of people sticking together and supporting you, they cannot touch you. It will be impossible. The day that you have people who are conscious of their dignity, when they have developed a better sense of dignity and of their rights, these oppressive measures will have to be abolished because they will be unable to deal with the people reacting. The only way to go is to really create a sense of urge in the population that if they do nothing, then these measures, as I say, will very you become eventually permanent measures, and then you never have what you had in the past. That might be too late.
Rise up.
I think in Denmark, they just dropped everything. It was yesterday, was it? And that's because they protested and resisted civil disobedience for about 2 weeks or more.
France and Italy doing the same.
But there will be even a rally, I think, on Saturday. So, I think you should always, everybody should actually go there.
Forest Lakes.
Forest Hill, in the city. Now, 12 p.m.
Yeah. Also on Saturday is take all your cash out of the bank day.
Yeah.
So if everyone over the whole world takes the cash out of the bank as much as you can, you're going to crash the banks. It'll be great to see. I love that. Yeah, don't go back.
Just a small point, on the 17th of March 2017, if you remember, Mark McGowan was elected. 6 months later, on the 20th of September 2017, he put in place the emergency WA law. Did he know COVID was coming?
Yes.
And is there, also I'm thinking, is there like a,
Well, he might know because he's so well connected with the Communist Party of China. So he might be told by his masters that he had to be prepared for the opportunity given to him to behave as a tyrant. But the only thing I have to say about him, there is even a video of him, and I have this in one of my articles, where he praises Wuhan. I don't know for what reasons. He says, "Go Wuhan." I don't know if he means by what he means is the virus, but that is very scary. And he says, "Go Wuhan, go China, China number one, China first, China first." That's the premier, like saying that China is first in the hand of the people here.
Yeah, China's given him the blueprint.
Everyone knows Mark McGowan moved into his $4 million mansion. Do you know all that? From Rockingham to Dalkeith.
yeah, also a point, there was a 60-minute show, which I can't find now on YouTube, where it showed a city in China. The whole city was with the QR code. Every shop had QR code. Everyone has to scan the QR code to buy something in the shop, and their mobile phones, everything was connected to their bank accounts. There were video, facial recognition. One guy got fined for just jaywalking across the road because every intersection has got cameras, and they give you a social score or something. They give you a score as
800
well.
points is the highest you can get. If you're a good citizen.
And they do this, and next when I see QR codes at the shops, you got to scan it, and I think I'm walking in.
Yeah.
But the point is, they got a Woolworths, I think, forum on as a trial where everyone, you can't buy anything without using your mobile phone and straight to your bank account. I found through the tradies at Bunnings, even before the COVID started, I want to use the QR code so a trader can go in, scan his cement and everything, and everything gets taken out of his bank account. And next thing I see it in all the shops here. So I said, this is China, right? All the way.
No, I couldn't agree more. I mean, it's thanks for your comments because I appreciate them enormously. Some of the things that I have said here is just like the beginning of my account of the facts, because there is this book that I edited, and it's together with some very prominent professors. So this is actually an edition of the Western Australian Law Journal, the Western Australian Jurist. And what I do here is to talk about, not me, but I was able and blessed enough to know the leading legal minds, not only in Australia, but all over the world, and they were able to contribute with articles in this publication about the causes of lockdown, about the use of emergency powers, the implications for fundamental rights and freedoms. I even have an article written by a person I happen to know. It's actually me. It's about the rise of governmental oppression. So it's a whole account of my impressions as a human rights advocate and a constitutional lawyer of what is taking place in this country. But I must say, when I say human rights, that I support real human rights and not fake ones. So that's why perhaps I was not as accepted. My nomination was not accepted to the presidency of the Human Rights Commission. Probably because they thought I would. My first measure was to close down the whole thing.
I would add that if Woolworths is doing what you're saying, stop shopping there.
Yeah.
That's still disobedience, you know.
Yeah, and Coles as well, because it seems that Coles is forcing employees to get vaccinated.
Go to the small retailers and people like that, but he's next.
Okay, so I just got one question. This may seem a bit different to what we've been asking. I've heard of someone who's renounced their citizenship. They renounced their birth certificate. How will they stand against all these laws? Or-
If you do so,
Yeah, it's the straw man.
Yeah, I've just heard of this, and I
Yeah.
just wondered, he done it for the reason he didn't want to be empowered by all these laws or whatever's happening. So how would they stand?
so the point is that Aristotle used to say that if you do not like politics, politics likes you. So it's the same thing about government. Even if you want to be isolated and free, they are never going to give you peace. You actually have to fight them. Yeah. So I don't think withdrawal is the solution. I think the solution is the best defense that has always been attack. We have to attack.
Yeah, but it's gonna be in huge numbers,
Absolutely.
huge.
That's why we are here.
Yeah.
Yeah, I have a close friend who's done that, he and his wife, and they have a lot of other problems. Yeah, in Perth, yeah, there's a group of people who did it in Perth.
Sorry, I heard it.
But I one day the very same question, and I said, what if they're coming door to door? How's that going to help you? He said, it's not.
Yeah.
Under the Constitution, isn't it supposed to be a free court system?
Well, the Constitution has a chapter called the Judicature, and originally, being a federal document, it was about the organization of one of the three branches of government at federal level. So the Constitution of the Commonwealth of Australia, in regulating the activities of the judiciary, refers to the activities of the Commonwealth Judicature. The judges are not entirely regulated by that particular chapter if they happen to be state judges. So you have something as derived from the federal model, where most of the provisions regarding the salaries and tenure of judges at state level are determined by either the state constitution or acts of the state parliament. And it is not entirely the most convenient thing, because the judges are not under the provisions of the federal judicature's chapter in the Constitution. Originally, the federal judiciary had only one court, that was the High Court of Australia, that was created in 1903 as a result of an act of parliament that established three judges only, because the Constitution of the Commonwealth of Australia refers to the composition of the High Court being of at least three judges. And these were actually the best judges we have ever had, because they had they were those who drafted the document in the first place, and they adopted something called the originalist approach. The point with even enacting a Bill of Rights, as it was mentioned, is that it can be manipulated and distorted by the judicial elite by means of what we can call judicial activism. So in America, the judges using the Bill of Rights, they have managed to even constitutionalize the slavery. And that's interpretation of the Fifth Amendment that guaranteed that the person should have the right to keep his property. So if he has the right to property, he should never lose his slave, which he is regarded as the property owner. So that was so serious that I have written even an article saying how that particular interpretation of the Bill of Rights actually leads to the constitutionalization of slavery and ultimately to the Civil War in America. So if you want to have a bill of rights, that's not going to necessarily solve the problem unless you instruct the judges to actually interpret the document in accordance with the intention of the drafter. Otherwise, they will find many ways in which they can manipulate the document so as to expand the reach and also to impose their own worldview upon others.
Any more questions? No. Oh, yes, okay.
With regard to the state of emergency, is it legal to actually, recently in WA, we have no, as far as I know, we have no coronavirus, yet they've just called it a state of emergency without being a state of emergency. I mean, how's that possible?
Well, don't ask for trouble. Better like that. Because what they can do is to create another excuse, you know. So it's better like that. Don't give them bad ideas, please.
Careful what you ask for.
Guys, I have to stay only about 10 minutes more. I'll tell you why. Because it has been such a tiring week for me, and I have been helping lawyers and things like that. I'm feeling quite tired now. But I would love to have you as my friends forever. So you can keep in touch. And another thing, you can visit my Facebook, you can email me, and we will be always friends. Thank you very much. I'd love to have your presence.
Thank you.
Thank you.
One final question, Augusto. Thank you so much. Solutions. Can you just leave us with one or two? I mean, obviously, gathering like this is really powerful and just getting knowledge, but is there one or two just final?
I think that we have to always stand for the highest moral ground. But when I talk about civil disobedience, it's not even the proper term to be used. We have to actually appeal to a lawful right to uphold the rule of law and to resist arbitrary government. I think everything is about mastering language and certainly have an approach that tells others that you're not in breach of the law, that you are doing this because the governments are violating the rule of law. And we have the right to resist a government that undermines your fundamental rights and freedoms in the process. So this is a very important thing. What I say, it looks not being so important, but we are going to enter in history for doing the right thing. But then we have to actually be very careful about how you phrase these things, because we have justice and righteousness on our side. We are actually doing things that are for the protection of our children. So you have to actually fight the good fight and speak truth to power and uphold the rule of law and resist tyranny. Lawful right to resist tyranny. And I must say that it's also very important that the solution, therefore, is extra institutional. So extra legal, extra institutional. You have the lawful right to resist a government that is in violation of the Constitution and of fundamental principles of the rule of law. Then, the only solution, or the best solution for the problem, is of a political nature. So you definitely need to get politically involved. And as Aristotle said, if you don't like politics, the politicians like you, and they want you to be used by them for the purposes of imposing their will upon others and utterly turning you into their slaves. So that's something that we are not going to allow to happen, and we are going to fight to the very end for our sense of human rights and dignity. Thank you so much. God bless you. God bless you.
Well, what an amazing afternoon we're having, folks. Unbelievable with Professor Zimmermann here, and we owe him a debt of gratitude, believe me. Obviously, we're going to be having a bit of a chitty chat and tea and coffee and all that shortly. I wasn't actually going to speak today, but I've just got a couple of things that I'd like to put across while we're here now. Some of you, obviously, we've got a very older audience here right now. Now, I'm just going to go through a couple of things that you might find actually quite interesting. This agenda that's been going on right now, that's led us to where we are now with this whole contrived COVID thing, the whole vaccine, let's go out and just try and do everyone we can possibly do, has been going on for a while. Now, as much as we've got technology is actually, in certain respects, our enemy. It's caused a lot of problems. These things here, okay? Now, you might not realise here, who is missing in our group today? Who is missing? The youth. Where are the youth? Now, this goes right back to Pokemon. That Pokemon device app that was set up, Pokemon, or whatever you want to call it, was an experiment. That experiment was a lead up to the experiment that we've got going on right now, which is these treatments under the guise of a vaccine. That was the first international global tracking system that was ever invented under the guise of a toy for children. Get out your phone, start walking around, pretend that you're chasing something, but you were being chased. Oh, and then McDonald's is supersizing you, and there's a little alert on your phone. It's all marketing, it's all globalization, and it's all big pharma and multicultural, or whatever you want to call it, corporations that are targeting youth. And they are making it cool to youth to be vaccinated. You are cool now, young Johnny. Okay, they are doing everything that they could possibly do for that. This goes with Black Lives Matter. Now, it also is the Greta Thunberg climate change. How dare they? Well, okay, Greta Thunberg, how dare they do what they're doing now to your youth that you were supposed to be protecting, because that was the agenda. Now, she's been marginalised. You're nowhere to be seen. So where is she now? She's not there because she's not cool for what we're talking about here. Okay? We need to make ourselves cool, and we need to make ourselves cool with youth. Now, as much as I hate these, youth is driven by QR scanning. They love it. They love every bit of technology that goes with these devices. So my agenda, and I have to say this is my agenda, I know it sounds pompous, but we'll just leave that one for the moment. I've got these little A4 brochures that are out the front there. There's about 5 of them. Each one of these brochures has got a QR scan code on there that any of these children can get hold of, and it'll bring up videos and all sorts of stuff. And I tell you what, it looks cool. They will want to get hold of one of these. We need to make our group, which has become a group as of today. Debbie said before, SW Freedom page. We are no longer a page. We are a group, and we're a face-to-face group. We get away from these devices. We get out in public. We have regular meetings. I'm going to try and work on that now with the next instalment of what we do as SW Freedom Community in the future. Next weekend, there is a rally up in Perth. That's a freedom rally on the 18th.
Stand in the park tomorrow morning.
Okay, we'll get to that later. So we'll get the 18th. We've got a busload, hopefully, of support workers, nurses, and people that maybe work in aged care going up to that rally. We're encouraging the nurses that are in this audience today to go and see Marissa, who's in her scrubs out the back there. We've got a 27-seater coach that we can have going up to that rally next week, and we would like the nurses that are here today to put up your hands and go and see Marissa when we stop for tea and coffee, and go up to that rally in your scrubs. Make yourself seen. This is what we need out of our nurses. They are the most important people that we have. So now, of course, we know that the youth is now targeting the 12 to 16-year-old age groups. That is criminal. Now, I network, I've had many conversations with Professor Augusto and Dr. John here, who's not the Dr. John that was the famous musician, by the way. He's a famous physician. I've had many, many discussions with these guys in the last week. Yeah. Exactly. He's a doctor as well. So, getting back to it, the target market now, globally, is 12 to 16-year-olds. And later on, down to 6-month-old newborns. The reason I'm standing up here in front of you is that I was trained as a surf lifeguard. I'm a medic, and everything about what I trained to do was all about prevention. I'm not married and I don't have children. Your children and your grandchildren are my children. That's why I'm doing this. We need to make our group cool. We need to be seen out more visibly on the street. And when we have this freedom march for Millions March for Freedom, it's coming to Bunbury on the 25th of this month. They have picked us now to come here. I'm networking with the group organisers from the East Coast, and I'm also networking with some very big leaders of other groups, not only in Australia, but around the world. It came to my attention this morning from Sue Gray in New Zealand, who's a lawyer. She's also the leader of a political party, and she's a microbiologist, that a 13-year-old schoolgirl died yesterday in New Zealand straight after the jab. We have to stop this. We have to stop that agenda to kill your children, your grandchildren, and all the other children that are going to get caught up in that. It's not going to happen, and we will not let it happen. Are we in agreement with that? Now, as we're an official group today, SW Freedom Community is now a group. We've got our lovely Colleen here, who's given us the hall today. We're going to be allowed to use this hall for future meetings. Yay. Wonderful. We can discuss all sorts of things there under general business, but we will be orderly and we will have an agenda and we will promote it on our page and on Facebook and on Telegram and everything else that goes with it. We'll get that information out to you. Now, getting back to what's happening with the nurses and industrial disputes and things like that, we now have a document that has come from a well-known person up in Perth in conjunction with some lawyers. I'm not actually going to give the names out at the moment because we're live on around the world on YouTube at the moment. We're going to fly up those documents on our whatever formats that we can get onto, the Word document. There is one for the employer and there's one for the employee. That document is going to be a standard document that the group leaders that I'm networking with right now are all going to use for that. So we won't be having 4 or 5 different documents with somebody who said, you need to use this one or you need to use that one. As a group, we'll be adopting that, and it's already had the legals go through it, and we just hope that that is actually going to do the job. So that will be available as of probably tomorrow. There's a few of you that might want it really urgently, and we have got people at the end of this week that are basically going to lose their jobs. Hopefully, don't sign anything from any of those employees. Do not resign. Whatever you do, do not resign. Even if you show up your place of work after they've basically released you, show up and just stand outside in your work uniform. Yes. Don't sign anything, whatever you do, and just say, okay, well, give me my separation certificate, and off down to Centrelink you go. Thanks very much, I don't have a job anymore. Thanks to Mark McLeod, he loves us all. We know what's going to be happening here. I don't have a crystal ball. No one in this room has a crystal ball. And this stuff is playing out as we speak. We don't know, there's a lot of laws that haven't been tested, but they have been tested as we speak. And you're not going to be able to run around with 4 bits of paper and just wave it in front of people and say it's all going to go away, and I have every right to do this and break the law. We're going to be very organised when it comes to doing, let's say, street marches or anything that's using the brand of SW Freedom Community. I will also be liaising with what you may see as the enemy. The police are not our enemy. They are workers and they are human beings. Do not demonise the police. They've got their own things going on within their building right now, and I'm also dealing with some folks there, right? So don't treat them like the enemy. So when it comes to being a well-organised force, which in conjunction with our big group and their leaders over in the eastern states, one of them being Michael Sims, you might know of him, we have an agenda of how we deal with the authorities. So if you're going to go out there, we will not be promoting you that you break the law. That's not our job. As an individual, you're entitled to do anything that you want out in public. That's great. But if we're going to go out there en masse during a lockdown, where you're going to go against directives, you're going to go against putting on masks, you're going to go against social distancing, the whole lot, it's got to be an organised thing. Now, when the police know that we're an well-organised thing, we're not a bunch of fanatics, which a lot of people think that we are, they will actually end up speaking to us. And they go, what have you guys got in mind? We've got a bit of a rumour out that you guys might be all invading and jumping out on the streets right now. They don't want to arrest 200 people, guys. They don't want to have you all getting marched back to the lockup. They'll just keep going. They'll be treated the same as the way they treat the bikies. When they go out there and have their big funerals and they're riding like maniacs and they're blocking their own streets and they're wearing no helmets, the police go, all right, guys, talk to the club president. You can do this, but you do it under our terms. So if we as a group are going to go out there and disobey, and we're talking about obedience, and sure, we're going to be disobedient, but you do it in a way that you don't end up with all of these things that we've just been through with the police and going to court for somebody that said, I don't have to give you my details to the police. I don't have to do this, I don't have to do that. And it was the way that that individual went about it that got his ass kicked. They were going to make an example. The admin and myself spent 4 hours in court with this individual. They were determined to fail, and they made that really clear, and they strung it out and strung it out and strung it out to put the fear of God in him in a closed hearing. Wow, not even open to the public. So they could do anything they wanted in that room, and they tried, but they didn't get away with it. But that cost him $1,000, guys.
And 6 months.
And
his wife kicking him out of the house and
exactly,
things.
Exactly. With a spent conviction, that means still he has a conviction, even though it's spent, right?
Can I
So,
just
yeah,
touch
okay.
on something for that?
Yeah, go.
Just quickly, just because it's on that topic. So I had a little word, I definitely didn't let on to the police officer that the prosecutor, like what my knowledge was about everything that's going on. I just acted dumb because I can actually do that when I need to. And asked the question that in the face mask directives or directions that they have that they're using to enforce us wearing masks, it states that you're exempt if you have a like some sort of exemption, medical, mental health, whatever. It doesn't actually state in there that you have to prove that. It doesn't state that you have to have a letter. The words out of her mouth were that that's what they want. So for Bunbury, for here, doesn't matter what happens in Perth, New South Wales, Queensland, New Zealand, our police officers in Bunbury want you to have evidence that you have an exemption. So whether that's a letter from a doctor or you've got a, psychoanalysis or something that can prove that you can't wear a mask, they're going to want that. So please don't try and argue the point with a police officer. Otherwise, you'll end up in the same person that this gentleman did, with like hell for 6 months of his life, thinking he was going to be locked up or fined $50,000. It's not worth the grief. Go to your doctor. do whatever you have to do. We're not recording.
Oh, sorry, we are. Do you want me to stop?
Yeah. I can be pretty dodgy when I want to be. Make shit up.
Yeah, exactly.
Get a medical certificate.